I'm sure I seem drunk, but mainly it's just abject terror and panic that no matter what I did, no matter what, I mean, a homeless shelter, like, do you have any idea how many guys have hit on me since I've been here? And I could easily be with them, but there was no way in hell I was going to go just sit and squat somewhere and not pursue job interviews and personal safety. And they still arrested me for it.
On the 4th of March, 2025, officers with the Williamsburg Police Department in Virginia responded to a civilian complaint near a public bus stop adjacent to a school playground. A named eyewitness reported observing a woman expose herself on a public sidewalk during school operating hours. The encounter that followed lasted nearly 51 minutes and raised 4 distinct legal questions. What constitutes legally sufficient probable cause for a warrantless public intoxication arrest when no breathalyzer is administered? What is the precise legal threshold separating misdemeanor indecent exposure from felony indecent exposure under Virginia law? When does witness uncertainty undermine a felony charge at the probable cause stage? And what are the constitutional boundaries of voluntary post-arrest statements under the Fifth Amendment? This analysis addresses each question in sequence.
Right? No, I had no idea I was in front of kids.
Okay, all right. Where were you?
At the bus stop waiting for the bus. I have a urinary tract infection. I have the medication. I can show it to you.
All right. Where'd that kid go? Here, let's come to my car.
Oh, thank you. Yeah, thank you. I'm so sorry.
Okay, so the reason that we have you right now is there's a gentleman who saw you pull your pants down in front of this. Okay. So, yeah, all right. I just want to make sure that it's you, okay?
Yes.
Because I already talked to you twice today.
Well, we talked once outside.
Okay.
So I can put it on medical record. Who's the gentleman that called?
Hang tight.
All right, sure. Do I have
Here,
to
come
have
stand
him?
in front of this car real quick
sure.
so you don't get hit.
Thank you.
Yeah. Just lean up against the bumper.
I have to be
Lean up against the bumper.
I have to
How
be
much have you had to drink?
Not much at all. I went back and I just relaxed. I have to be at the target by 5:45. Yeah, I'm definitely not intoxicated. You can do a
But you just had a drink somewhere else?
Well,
You just went into
I had iced tea.
Strange Ways
I was
and had
at
a
Strange Ways.
Prosecco or something like that?
Right, but then I just sat outside for an hour. I sat outside for a full hour.
Okay.
Yeah.
All right.
I feel like people are following me. My sister has my power of attorney and all that. I have to be at Target by 5:45 or I can't get to the shelter.
Okay.
Unless I get a police
hang tight.
escort and
That's
shit.
a arrestable thing, right? That's like arrestable, or is that like
It's a
a...
class 1.
So yeah, it is. I don't know anything about that, but I know it's...
Yeah.
Yeah, like tomorrow the only plan, I met with my case manager today. I have therapy on Thursday.
All right, so it is...
I'd run it by LT just because of the daycare thing.
Yeah.
I don't. Yeah.
Okay, hang tight with them, okay?
Yes.
Because that might make it look better.
The encounter begins as a lawful investigatory stop under Terry versus Ohio, 392 United States 1, decided in 1968. The Supreme Court held in Terry that officers may briefly detain a person based on reasonable, articulable suspicion, a standard materially lower than probable cause. Reasonable suspicion requires specific, articulable facts that, taken together with rational inferences, justify the intrusion. Here, the officer possessed a report from a named civilian eyewitness describing a specific, observable act committed moments earlier at a specific location. The subject was located at that precise location, matching the description. The Terry threshold was not merely met, it was substantially exceeded. A named witness providing contemporaneous, location-specific information carries considerably more weight than an anonymous tip under the framework established in Florida versus JL, 529 United States, 266, decided in 2000. The initial contact was lawful without qualification.
Oh, yeah. 285 Suncheck, you show me out with the subject.
Sure.
The transportation center.
Sure.
Greg, I can't.
285 to 265. $285 to $265. Attention. Any child between the ages of blah blah blah, any public place, intentionally expose a pervert to a minor under 15. Try to call him. Oh yeah, I'm looking it up. Yeah, I got that, but it's. So there's nothing specifically about a child?
Were their kids out?
I guess I gotta ask him. I'll probably have him write a statement, huh?
I swear the first time I passed by they were, but probably when she did that, the teacher brought them inside. So.
Okay.
It's still during hours that the kids were there. And it was directly in front of
Directly
there?
in front of.
Okay, and she was facing it? Or how was she?
She was facing the road with the playground behind.
Okay, so she was right next to the playground, basically, on the sidewalk?
Yeah, in front of
Okay.
the fence.
Did she, like, squat down or do anything like that?
No, she just completely, like, pulled him down, all the way down to below her knees.
So dropped him?
Yeah.
And then pulled him right back up?
Once I turned around and went back towards her direction, they were already up, so yeah.
Say that again?
Once I turned around and went back towards her direction, she had pulled them up by then.
Okay. All right. Hang tight for me. I can't get a hold of Greg.
Yeah, I can't get a hold of him.
Yeah, what the I'm gonna call.
Is he with, he's with Dolac, I think, right?
Yeah.
The only, what's Dolac's name? 258. The only other thing would be if you just dipped her and just hit her with a decent exposure.
Yeah, that's why I was trying to pull off to the side really quick to see if I could smell it, because I could see her face was more red. So I was trying to like smell it, but
She said that she drank. So she
drank at that one place.
2 Bud Lights and the Prosecco, and then after that, now she's on the side of the road, pulling her pants down.
yeah, I mean, I was ready to arrest her. I just wanted to make sure that.
Yeah, it's enough for a dip. But
Virginia Code Section 4.1, 322, the public intoxication statute prohibits being drunk in a public place. The offense is classified as a Class 4 misdemeanor. Critically, the statute contains no requirement that an officer obtain a blood alcohol content reading before making an arrest. The constitutional question is whether the officer's probable cause for the public intoxication arrest was legally sufficient under the Fourth Amendment. Probable cause exists when the totality of the circumstances known to the officer at the moment of arrest would lead a reasonable officer to conclude that a crime was being or had been committed. This is the standard established in Illinois v. Gates, 462 United States 213, 1983, which expressly replaced the more rigid, two-pronged Aguilar-Spinelli test with a holistic, common-sense analysis. The officer's probable cause packet for the public intoxication charge included 4 independent elements. First, the odor of alcohol detected through direct olfactory observation. Second, visible flushing of the face. Third, behavioral indicators including unsteady movement and disorganized speech. And fourth, the subject's own voluntary admission to having consumed alcohol earlier in the day. No single element is legally required to stand alone. Collectively, these observations far exceed the probable cause threshold. The subject's demand for a blood alcohol content test reflects a widespread misconception. Virginia law imposes no such pre-arrest requirement. The Supreme Court addressed this structural point directly in Virginia v. Moore, 553 United States 164, decided in 2008. The court held that a warrantless arrest for a minor offense does not violate the Fourth Amendment when probable cause exists, even if state law would not have authorized the arrest under different circumstances. The court's reasoning was explicit. The Fourth Amendment's reasonableness requirement is satisfied by the presence of probable cause, full stop. An officer's failure to administer a breathalyzer does not retroactively eliminate probable cause supported by direct observation. The public intoxication arrest was constitutionally sound.
All right. Can you put your purse down real quick?
Yes, of course. Yeah, I just
All right, put everything down.
Sure.
Thank you. All right, turn around. Hands behind your back. Hands behind your back. You're going to be under arrest for being drunk in public, okay?
If you have a BAC.
No, we don't need to have that.
Well, I'm not.
Hands behind your back.
You appear intoxicated in public.
And you.
You have a blood alcohol.
I'm required to give you one first on the public.
Okay, but you say you don't have one.
You'll be in charge of that and decent excursion.
Okay, do you have a video of the indecent?
We have a witness.
So you just have a witness, but
that's
no
all I
video.
need.
Okay, so the witness is what?
Yeah.
I have a credible witness. That's all I need.
All right.
Are you going to get my purse?
Yep.
All right, stop. Turn around real quick. Do you have anything on you? Go ahead and separate your feet. All right, I'm going to search you. Stop. Scooch over to the side to your left a little bit. Separate your feet. Separate your feet. Do you have anything on you?
I do not.
Okay. Just
So
go ahead and
Elizabeth's
face my
still,
car.
my sister's
Go ahead and
free
face
now?
your car.
My sister's free now. Wait till I get a phone ring, Elizabeth. Guess I'm what? Your hot River House boyfriend.
Okay. Go ahead and sit down.
So did you talk to the eyewitness yourself?
Yes.
Okay, so we'll go to court.
Yeah, you definitely smell like alcohol now that I'm closer to
Well, you know, you smell like perfume.
you. Thank you.
Yeah, when you're walking, I got a whiff of it.
Yeah, I was like, when I was over
The wind
there.
was blowing back.
Yeah.
Yeah, just so happened. And then, yeah, that decent excursion. And I think there's a city code for like
There might be.
I need to double check. There is one.
I can look in this.
There's
right?
like something
Should be.
for like bodily fluids.
That's going with you to the jail. You gotta make sure there's
Yeah.
something.
Shit, I should have gloves on.
So that should
Sure, yeah. Dude, I can't find my so small glass. I've had like 4 different cars.
Because they're large, so pick them up.
It's don't work. You said my handcuffs were locked?
Yeah. I'll get down here.
Alright.
say like how close she was to the daycare or anything?
Like she was right on the sidewalk, and she was facing Richmond Road, but like her.
Were their kids out?
He told Dom that he wasn't sure, but it's still within the hours of them being there, so I don't know if there's windows. But I know I was briefly searching for it, and I was trying to get a hold of LT.
This is the most consequential legal question in the encounter, and the one the officers handled with the most analytical care. Virginia maintains 2 separate indecent exposure statutes carrying dramatically different penalties. Virginia Code Section 18.2, 387, the baseline misdemeanor statute prohibits willful exposure of private parts in a public place or any place where others are present. This is a Class 1 misdemeanor, carrying up to 12 months of incarceration and a $1,000 fine. Virginia Code Section 18.2, 370 creates a felony enhancement. A Class 5 felony carries 1 to 10 years of imprisonment and triggers mandatory sex offender registration under Virginia Code Section 9.1, 901. The enhancement applies when the act is committed in the presence of a child under the age of 15. The critical term is presence. Virginia courts have not issued a definitive appellate ruling precisely delimiting what presence requires under Section 18.2, 370 in the context of public exposure near a school. However, the statutory language is unambiguous. The child must be present. Operating hours alone are not a legal substitute for that element. A school being open does not establish that any specific child observed or was proximate to the act. The distinction between a school's scheduled operating hours and actual confirmed child observation is a distinction with legal consequence. The eyewitness in this case explicitly told officers he was not certain whether children were on the playground at the moment the act occurred. This uncertainty is not a minor evidentiary quibble. Every element of a criminal offense must be supported by probable cause before a charge is filed. Under Beck v. Ohio, 379 United States 89, decided in 1964, the absence of probable cause as to any single element defeats the lawfulness of an arrest for that enhanced offense. The officers reached the correct legal conclusion. Charging the felony on this evidence would have been constitutionally infirm. It would have exposed the department to civil liability under 42 United States Code, Section 1983, and would almost certainly have failed at the preliminary hearing stage. The decision to charge the misdemeanor under Section 18.2, 387 reflects legally defensible judgment. One further point merits emphasis. The misdemeanor charge does not require a child to be present. It requires only that the exposure occur in a public place or a place where others are present. The eyewitness observation, a named individual who directly observed the act, satisfies the probable cause requirement for the misdemeanor without the child presence element.
Hey, real quick, what is this?
Tea. Unsweetened iced tea. You can throw it out.
All right.
So you have someone that called you and said I was indecent public, but no proof of it.
If you really want, I could go around all those businesses and I could find footage because there are plenty
That's
of
fine with me.
plenty of cameras around
Well,
there.
we're going to do it because there was...
Well, we're not going to do anything. You could go to court and you can do all that, and I'll go to court and I'll do my thing.
Public, and I don't appreciate going to a homeless shelter and being told I'm a drunk. If I was a drunk...
Nobody
I'd
called you a
all
drunk.
night when
Nope,
you-
nobody called you a
know
drunk.
What you're doing? You got a phone call? So you're arresting me off a phone call?
Nah, not really.
Yeah.
Okay.
So you can say in your opinion?
In my training and experience,
In your
and just being an adult and knowing what a drunk
In
person
your
looks like and acts
opinion,
like.
I'm drunk in public?
Yes, ma'am.
Okay. Do you have a BAC when we get to
I
the
don't need
police
one.
station? Do you have one when we get to the police station?
We're not going to the police station. We're going to jail.
When we get to jail, do you have one? So I have to be arraigned, stay in a jail cell based on someone calling you, and I'm in an inheritance battle with my family. They had to have it. Mike, Mark, Elizabeth, Robin had to have what jail looks like for an excessive long haul.
Okay.
So my day tomorrow was Publix, and Thursday were 2 job interviews. So you're telling me Mark isn't your new boyfriend? He likes blondes with pretty blue eyes. So we'll make sure that y'all don't have a personal association. So no matter what I did, Elizabeth, the free joy in your sister's life will be put down on a concrete step. Correct? Eight out, 4 hours, 6 hours. Thank you, Grandma. How many times did I call my mother? How many times did I ask you to come and stay with you right now so this wouldn't happen? So it's her interview! Look at Jahari in the officer's eyes using Amy. Robin, another woman's daughter will have a $500,000 deposit for retirement, whereas she was only looking at $125,000 if she stayed for 20 years. So she's now got $500,000 to $1 million because your daughter is in handcuffs for another 8 hours. Your daughter is in handcuffs.
You hear her screaming?
I'm sorry.
Oh yeah, she's screaming. I'm looking for my criminal complaint template, but I fucking had a question. Oh, she keeps saying that she wants to do BAC. That's not something that we have to give, right? Okay, I didn't think so. It'd probably be a good thing for you to stop screaming.
I would agree.
Yeah.
What I would have preferred to have happened is not being arrested for hearsay.
The subject raised a legally framed argument during the encounter that the arrest was based on hearsay. This argument, while understandable, applies the wrong evidentiary standard to the wrong stage of the proceedings. Hearsay rules codified in Federal Rule of Evidence 800 and in analogous state provisions govern the admissibility of out-of-court statements offered to prove the truth of the matter asserted. These rules operate at trial. They do not govern probable cause determinations for arrest. The Supreme Court addressed this distinction in Illinois v. Gates. The court held that information from a civilian informant or eyewitness may support probable cause when evaluated under the totality of the circumstances. The relevant factors include the basis of the witness's knowledge, the specificity of the information, the contemporaneousness of the report, and any indicia of reliability. A named civilian who personally observed a specific act and reported it immediately to law enforcement is among the most reliable categories of probable cause sources recognized by the courts. The appropriate forum for challenging the sufficiency of the eyewitness account is a suppression hearing under Franks v. Delaware, 438 United States, 154, decided in 1978, or at trial where the witness testifies subject to cross-examination. The arrest stage is not that forum.
Have you heard that? Based on your training and opinion? So the bill was paid. We're going to go back on their cameras to when I got the bill to when the bill was paid. And we'll look at the timing. And we'll talk about whether it's belligerent with you and the officers. And then we'll
I'm not
talk about
discussing
how,
anything.
based on a phone call, you have arrested me because you think I'm drunk.
You can just look at all the
bill
paperwork
was
afterwards.
paid.
Nobody's saying that.
And I was going to a homeless shelter to sleep and not get arrested by an ex-boyfriend or my sister. But you as a female police officer have decided to arrest me for being illegal. Congratulations. Your Johari input. And Mark, if Sealdor has another blonde Nazi that is the prettiest female he's ever seen. I am completely law-abiding. And good job, Robin. No matter what, they are breaking her. So Ashley, after she got put back in jail for 6 months, now has Johari, Robin? So you think they're going to give it to me? How many times did I call you and ask you for help during this period? And I am now under arrest for no reason. I called you over and over and over and over and over and over and over again. And you handed me to Mark's girlfriend and Elizabeth. She's showing me how to relax underneath the loving gaze of my new boyfriend.
Careful.
Ah!
What are you doing?
I am hoping we can get to the jail so I can have one hand free. Elizabeth needed a jail! Intake! Elizabeth Teal needed! Look, lady, I can go after your career. So are we ready to go yet? Are you ready to untame me? Are you ready? Because I don't have the $2,500 for a lawyer, so congratulations. Your mega shot, which I'm
285
sure
Central.
is on public record, now has a valid reason, correct?
285 Central. I'm en route to VPIJ beginning match.
Mega shot, blonde, blue eyes, Robin.
24636.
Big tight.
10-4, 24636. 248 Central North Carolina DL.
Good. What color
430-28791. You can log it.
When you pass me and the child play crib. So the plan, Robin, was for me to be cooler about it and go out. And since I didn't, I'm under arrest. How many times do I have to tell you that choosing the safe way out meant I'm under arrest? So you've got me. How long, Robin? How long can you go up and tell people that I'm on a drug rehabilitation, drug court outsourced program? Robin! Elizabeth Teal needed an arrest. How much, Robin? How much longer am I under social arrest?
Minus clear. Robin Teal, are you ready? You knew I needed help. I called you over and over and over and over and over. I called you for help. Look at Mark! His new blood! If I put my finger in my crotch and consciously it again, you'll get a point for getting me over my fear of a strip search. we have to exonerate Lawyer Brooks. Oh, is he okay? You had a chance. If you want to ride the black pony. If you want to come up upon me. If you want to come. Look at Mark. Oh, the children. Mark's children. I don't even know their names, their birth dates, or where the f they live. So why did Mark's children need a damn rescue from this bitch? I called you over and over and over. You neglected and abandoned.
I'm so sorry, officer. It's not you. It's been I just, day after day after day, my mom has a $500,000 home, and my family has a $250,000 home. And since my dad passed, I'm suddenly the person I was in 2013. Just, by the way, I mean, I'm not kidding you. Like, every ounce of my daily life is to do the right thing. Like, I have a college degree. I've worked at McDonald's. I've worked at Food Lion. I've worked at Giant. I've worked and worked my ass off. And all she had to say was, she's not allowed to a single cent. Here we go, Robin. If I agree, Sheila, to Busch Gardens! I'm sure I seem drunk, but mainly it's just abject terror and panic that no matter what I did.
Following the formal arrest, the subject made extensive voluntary statements over the course of approximately 40 minutes. No Miranda advisement was delivered on camera prior to or at the point of arrest. Two distinct legal questions arise. First, does the absence of a Miranda warning render the post-arrest statements suppressible? The answer depends on whether the statements were the product of custodial interrogation. Miranda versus Arizona, 384 United States, 436, decided in 1966, protects against the compulsive pressures of custodial interrogation. It does not suppress voluntary, spontaneous statements made without prompting. The officers did not interrogate the subject after arrest. They did not ask questions about the underlying offense. The subject's statements were entirely self-initiated. Under Rhode Island versus Innis, 446 United States, 291, decided in 1980, interrogation means direct questioning or its functional equivalent actions by officers that they know are reasonably likely to elicit an incriminating response. No such conduct occurred here. The officer's silence and passive observation do not constitute interrogation. Second, can the voluntary post-arrest statements be used against the subject at trial? Under Colorado versus Connolly, 479 United States, 157, decided in 1986, voluntarily made statements without coercion are admissible regardless of whether Miranda warnings were given, as long as the statements were not the product of interrogation. The subject's extended voluntary monologue is therefore likely admissible at trial as a party admission under Federal Rule of Evidence 801, subsection D, paragraph 2, or its state equivalent. The practical consequence: the subject's post-arrest conduct may have strengthened the prosecution's case on the public intoxication charge rather than weakened it. Disorganized, prolonged, and emotionally volatile speech over a 40-minute period after arrest is consistent with the behavioral indicators the officer observed before arrest. Defense counsel will face the challenge of recontextualizing this conduct as the product of emotional distress rather than intoxication.
No matter what. I mean, a homeless shelter, like, do you have any idea how many guys have hit on me since I've been here? And I could easily be with them, but there was no way in hell I was going to go just sit and squat somewhere and not pursue job interviews and personal safety. And they still arrested me for it. I met with my case manager. I have therapy. No matter what I did, you group of people needed a police intervention. Thank you for taking me by yourself. I am totally not a loud or obnoxious person. So this morning was interview 1. Somehow that ends in arrest, Elizabeth. What color sweater were you wearing on Richmond Road 10 minutes before this police officer, who looks like a cheerleader from Tennessee, who's already more high than most of us could fathom and needs a guinea pig? What color sweater were you wearing, Elizabeth, to give her a state badge in Jaharite, not just a local? What color, Elizabeth? So the whole idea is, our dick, we settle you down. Bullshit. 16, Elizabeth? You need March 2016, correct? So if I'm here for 30 days and then I'm on probation, then you're damn bus of freedom? Otherwise, my 14-year effort towards freedom and work was handled before you got a thing, correct? So you got, I'm so sorry, officer. You're being so nice. I can't even believe it. I can't even believe it. She could easily have called backup, pulled me over. Like, that is nice of her to let me get upset like this. I can't even believe it. Mark, Michelle will go on the witness stand. And her 4 daughters and their perfect little security clearance. And she's not the only Michelle, right? I'm looking at 3 right now.
The physical force employed in this encounter was limited to handcuffing and a search incident to arrest. Both are evaluated under the objective reasonableness standard established in Graham v. Connor, 489 United States, 386, decided in 1989. Graham identified 3 primary factors: the severity of the crime at issue, whether the subject poses an immediate threat to the safety of officers or others, and whether the subject is actively resisting arrest or attempting to evade arrest by flight. The offense at issue, public intoxication, a Class 4 misdemeanor, is at the low end of the severity spectrum. The subject posed no articulable physical threat and complied with handcuffing commands after verbal protest. The search incident to arrest was authorized under Chimel v. California, 395 United States, 752, decided in 1969, which permits officers to search the person and the area within the arrestee's immediate control following a lawful custodial arrest. The search was procedurally appropriate. No excessive force occurred. The physical interaction in this encounter does not raise constitutional questions under Graham or its progeny. One tactical note: during the initial contact phase, the subject was briefly positioned near active roadway traffic. While this did not produce injury, it represents a preventable officer safety and subject safety exposure that does not align with standard field positioning protocols. The subject repeatedly characterized the arrest as motivated by factors unrelated to the alleged conduct, specifically a family inheritance dispute and the involvement of identified third parties. This characterization implicates the retaliatory arrest doctrine examined by the Supreme Court in Nieves v. Bartlett, 587 United States, 391, decided in 2019. Nieves established that a plaintiff alleging retaliatory arrest must generally demonstrate that the arresting officer lacked probable cause. Where probable cause exists, a First Amendment retaliatory arrest claim ordinarily fails. The court carved out a narrow exception, where officers have probable cause but objective evidence, such as video footage, demonstrates that the arrest was motivated entirely by protected speech or conduct. A retaliatory arrest claim may proceed. In this encounter, the probable cause basis was established before any protected speech occurred. The eyewitness report and the officer's independent observations predated the subject's post-arrest verbal conduct. The subject's post-arrest statements, while constitutionally protected as a general matter under Cohen v. California, 403 United States 15, decided in 1971, did not cause the arrest. The arrest preceded the escalation. A Section 1983 retaliatory arrest claim based on this encounter would face a significant threshold obstacle under Nieves, the documented probable cause established independently of the subject's speech.
DPRJ Control, how can I help you?
Williamsburg, one male or female.
10-4.
Sorry, say that again. Yeah, that's what I saw, but then it doesn't say it in there, so I always have issues with like the magistrate saying that it's not the right one. Yeah. I look before I go in there. Alright. No, that's fine.
That was Elizabeth, Robin, on the phone.
Oh, my name's not Elizabeth.
Hi, pardon me, officer. I'm so sorry for screaming. I've been fighting tooth and nail. I promise you, I'm an inherited, and I know you can only see what you've heard today. I can't even. I paid my bill at that restaurant. Like, it wasn't like there was a delay between my asking for the bill, telling them I might need a moment, try to run my card, give me 45 minutes, and I promise you, every time the waitress came, I said, "Are y'all still okay?" I said, I'm here most of the day. I'm staying at the shelter. Yeah, we're fine. Don't worry about it. So all of a sudden, y'all were there, and then I promise you, on my honor, I have a UTI. I did not pull my pants down, and I promise you,
that there will be no evidence of this charge. So how do you think that makes me feel? Like, I'm already in a shelter. I could be boffing some dude. There are 15 Latina cooks. Trust me, they've been hitting on me. I was already clipped. She has brand new Jaharite, Robin. Higher than she's ever had. So this is her big day.
Okay. Sorry. So were you saying, before I lose service, you're saying that those words probably need to be in there in order for 387?
So Elizabeth spoke to her just now on the phone.
Yeah, because when I asked him, I was like, so full on? And he said, yeah, but then I guess I didn't specify. Yeah. Okay.
She is higher than most people are, but she's professionally a police officer.
All right, cool.
So getting me
All right.
gives her an advancement and professional placement. However, she also kind of believes me. And she's also telling me that my sister was going to continue to do it, so they might as well do it. Robin, you is 12 months of probation. I could be shagging the Mexican cooks right now. Do you understand?
Ryan or Joseph? I'm looking for Joseph. Okay, hey. Okay, this is Officer Ebola. I have a quick question for you. So I'm pretty sure that I asked you. I just want to make sure before I go in front of the magistrate. Was she full on nude from the waist below? Okay, so no underwear.
Says who?
Completely nude from the waist down. Okay, all right. Thank you. Bye.
Okay, well, we'll refute it in court.
Okay, no, I just had to ask the witness, so.
Was that the witness or the witness's
Correct.
spokesperson?
It was.
Okay, well, the witness and I will meet in court. So I can be arrested because a witness said I was nude.
Absolutely.
Okay, well, I will say differently to the magistrate now that you're having an interview with the magistrate about nudity while high on Jaharite. He will need to have a picture, but regardless, Robin, your daughter was dominated against money. And Elizabeth and Robin have another 12 to 18 months of holding me under their crutches while they safely usher their destinies home, correct? Good job, Robin. I mean, we all know the I'll see you tomorrow, or this is what you'll have weekly, or I'll take you to therapy was a lie, right? Well, they have us go right away, officer. So now, Amy's perfect arrest record, lauded for her respectability, calmness, and politeness, Elizabeth. Elizabeth, FBI. He bought me two.
This is 265.
Go for him.
I have a pending legal and reference to cease and desist letter. It's going to be a phone call request.
270 Central, you can clear me from the noise complaint. Assign that to me.
Yeah, thank you.
Central, you still have me on that walk in the lobby?
I do.
There was a report.
So,
Amy's trauma is caused by jail recollections that she refuses to acknowledge. When did I say that was the case, Lindsay? How much longer does she have, Robin, before she gets her police badge? You didn't buy me two, Mark. You raped me twice. Are you ready? You got about 40 minutes till you gently slide in the bitch you put down for personal freedom.
So I was looking at the code. I just want to make sure before I don't have service. It was 387, but then I found 370, which is for...
this is 265.
Hey.
We received a heads up from James City that there's going to be a protest going to be happening at the courthouse. About 200 people protesting Ukraine. It's currently happening.
Yeah, so 182387 was what I was going for, but now the 370 is a felony, and it has to do with children under 15.
Okay, well, if you go for that, then I will take your license. I will not accept a felony for something I didn't do. Congratulations, Robin! Your daughter's future is over! You tell his blood, you tell that motherfucker that I'll find his fucking I'll find his fucking balls!
So and it was right in front of the playground. Now the person calling said that they weren't sure if there were any kids on the playground. It's still within the operating hours, so I'm not sure how that works, but I was
Well, you'll have to decide how the city of Williamsburg can have a charge without proof in front of a playground. Sheila!
Okay.
So no matter what I did, Robin! A sex offender! Registry! I'm telling you, officer, you've been so nice to me, and I apologize for the verbiage because I've never had a police officer allow me to do that. But if you're going to charge me with a felony, you better be ready to prove it! Are you, Robin? So you're kind! You're blind! Motherfucking cunt! Daughter can get her license! You fucking, you whore! You bitch! I am in jail! In jail for going to a shelter, not doing drugs!
Alright, I got your purse.
Do not suggest the felony, or we have a problem.
I think you already have a problem.
Yeah, I think we do. You're a liar. But congratulations on your Jehoran shot. Fuck you, Robin! Congratulations, Robin! I'm f***ing you. Not even a f***ing misdemeanor! No matter what the f*** I did! No matter what the f*** I did!
I'm gonna pull you out of the car. You're gonna relax.
You're not gonna charge me with a felony.
I haven't said what I'm charging you
Thank
with, have I? Okay? You're gonna calm down before I bring you out of the car.
Homeless shelter,
Stop.
no drugs.
I'm gonna pull you out, and you're gonna comply with me. You're not gonna
Absolutely.
be acting the way you were right now.
I
Okay?
can't even believe you've allowed that. My family.
Step out.
Thank you.
Right here. Turn around.
The arresting officer receives a B-. The probable cause basis for both charges was legally sound and independently developed. The decision to decline the felony enhancement in the absence of confirmed child presence reflects a command of Virginia's indecent exposure statutory structure that directly avoided constitutional overreach. The officer maintained professional composure throughout a 50-minute encounter involving sustained provocation at a level that would test most law enforcement professionals. The deliberate consultation with command before committing to a charging decision reflects appropriate institutional practice. 3 factors prevent a higher grade. The absence of a Miranda advisement on camera prior to arrest is a procedural gap technically non-prejudicial in this case because no post-arrest interrogation occurred, but a best practice failure nonetheless. The positioning of the subject near active roadway traffic during initial contact created a preventable safety exposure. And the probable cause basis for the indecent exposure charge itself relies on a single eyewitness whose account included self-identified uncertainty, a vulnerability that will persist at trial. The subject receives a C+. The subject correctly identified, if imprecisely articulated, the central evidentiary weakness in the indecent exposure charge, the reliance on a single eyewitness. That intuition was legally sound. Physical compliance with handcuffing commands prevented the encounter from escalating beyond a misdemeanor arrest into a use of force incident, which reflects rational decision-making under stress. The voluntary disclosure of a medical condition at first contact was appropriate context setting. However, the subject's decision to speak extensively after arrest without legal counsel and without the protection of silence represents a legally self-defeating choice. The Fifth Amendment right to remain silent is the single most powerful legal tool available to a person in custody. It was not exercised. The post-arrest monologue, which continued for nearly 40 minutes, generated a sustained evidentiary record of behavioral patterns consistent with the charged offense. A demand for attorney representation, rather than a demand for a breathalyzer, would have been the correct legal response. The Williamsburg Police Department receives a B. The correct identification of the felony threshold issue, the consultation with command on that question, and the ultimate decision not to overcharge the case suggest an institutional culture that values legal accuracy over reflexive escalation. The officer's de-escalation approach during a prolonged and emotionally volatile encounter suggests effective training. The department loses grade points for the Miranda advisement gap and the tactical positioning issue, neither of which rose to a constitutional violation, but both of which represent training opportunities. 3 lessons emerge from this encounter with practical application beyond the facts of this case. First, the distinction between probable cause to arrest and proof beyond a reasonable doubt is not merely academic. Probable cause requires only a reasonable belief that an offense was committed. Trial conviction requires proof beyond a reasonable doubt. The evidentiary gap between those two standards is where most contested cases are won or lost. In this encounter, the public intoxication charge carries strong evidentiary support. The indecent exposure charge rests on a single witness account containing its own uncertainty. An arresting officer's job ends at probable cause. A prosecutor's job begins there. Second, operating hours are not a substitute for element-specific probable cause. The proximity of an act to a school, a daycare, or a playground during operating hours does not legally establish that a child actually observed or was present during the act. When a statutory enhancement requires a specific element, child presence, victim status, use of a weapon, every element must be supported by independent probable cause before the enhanced charge is filed. Proximity creates inference. Inference is not element-specific probable cause. Filing a felony based on inference alone is a constitutional exposure risk for the department and a procedural vulnerability for any prosecution. Third, the Fifth Amendment right to remain silent is not a technicality. It is the most durable legal protection available to any person in custody. Silence invoked clearly and maintained cannot be used against a defendant at trial under Doyle v. Ohio, 426 United States 610, decided in 1976. Voluntary statements can. The practical gap between those two legal realities is the difference between a prosecution with strong behavioral evidence and a prosecution relying exclusively on a witness whose own account contained expressed uncertainty. The subject's choice to speak rather than remain silent may have been the single most consequential legal decision made in this entire encounter. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.